All right, good afternoon, everyone. While you're settling down, I'd like to welcome you all here. My name is Raymond Koo. I'm one of the co-directors of CASE's Center for Law, Technology, and the Arts, and this will be one of many programs that we have in the future, not only brought to you by LTA, but also in collaboration with the ACLU here of Northeast Ohio. We have as our guest speaker today Chris Hansen. He's a senior counsel at the ACLU in the National Legal Department. Chris has been the lead counsel of numerous important civil rights cases and civil liberties cases. If I were to actually list them, we would be here much longer than actually the time would allow for his presentation. But to give you a little bit of a note, Chris was also one of the first instructors I ever had in the practice of law. Before I even went to law school, I was an intern at the ACLU in the Children's Rights Project, where Chris was an attorney. And one of the things I learned there was both the importance of litigation and the skills of lawyering, but also the limits and frustrations of impact litigation, as one of the first things I saw when I sat in his office was a picture and map of Topeka, Kansas. And I looked at him as a curious person and said, well, why do you have that? Was it a historical anachronism or a keepsake from Brown versus Board of Education? And of course, that was the caption on the map. And Chris said to me, turn it over. And underneath was actually the map of Topeka, Kansas from the original litigation, and the top map was where Topeka, Kansas was and how it was still segregated at the time in the early 90s. Right? So Chris informed me quite clearly that he was actually counsel of record for Brown versus Board of Education in the most ongoing and recent litigation. And has been an important role and force in kind of civil rights and civil liberties litigation ever since. So it's my distinct pleasure to bring a former kind of instructor and mentor here, and I won't say how long it's been since we've both been involved in this, and to welcome him here to CASE. So thank you.
So we may be in the middle of academia, but I'm here to talk about sex. I almost don't have to go any farther, I think. But actually, I mean, it's sort of true and it's sort of not true. I mean, one of the things that actually drives me crazy about doing all these cases is that people think that these cases are all about dirty books or dirty pictures or things like that, and they're not really. They're about the First Amendment and they're about free speech, and I hope to sort of explain why I think that's the case. So the story about the free speech on the internet starts back in the 90s when no one had been on the internet. I hadn't been on the internet, nobody had email, nobody had internet access, and the New York Times started publishing articles about this odd thing called the internet and talking about how it was a coming thing. And at the ACLU, we began thinking to ourselves, well, if this is a new medium of communication that's going to arise, we got to start thinking about whether there are any First Amendment implications to this new medium of communication and what role, if any, the ACLU should be playing in helping to figure out what the rules are going to be with respect to this new medium of communication. And so we found somebody who could show us what the internet looked like, and I remember being wowed that you could get to a French website just as easily as a US website. Because my head was in the context of long-distance telephone calls. And it was much harder to make a long-distance telephone call to France than it was to make a call across the city. And somehow the notion that the internet could break that paradigm, could break that model, seemed quite remarkable to me. But it was all still relatively mysterious. When we filed the first case, Congress was just as concerned as we were about where the internet was going and what the nature of the speech that would take place over the internet was. And so Congress very early on passed a law called the Communications Decency Act, which made it a crime, a serious crime, to engage in any speech that is indecent on the internet if it was accessible to a minor. Now, of course, all the speech on the internet is accessible to minors. There's no way to tell the age of the person who's looking at your internet web page. And so that meant that all of the internet was going to have to be dumbed down to the level that was acceptable to minors. And so we began thinking that this was a cool law that we ought to challenge. And we did. The first thing we wanted to figure out was who are our plaintiffs going to be? Who's going to challenge this law? We didn't have, the ACLU didn't have a website. Nobody we knew had a website. So we had to go out and buy a computer that had internet access, and we had to figure out a way to get internet access, which actually turned out to be relatively tricky for us. But we finally figured out how to do that. And one of the lawyers on the project went trolling for internet websites that might potentially be at risk in the lawsuit. And we were looking for internet websites that were talked about sex in a frank and adult way, but that weren't porn. We didn't want to represent the porn industry. And we found a lot of really good websites. The other thing, though, that we were concerned about was we really wanted the case to be called ACLU versus whoever. It turned out to be ACLU versus Reno. Because we thought it would be cool if this is going to be the very first case that's involved censorship on the internet. It'd be really cool to be able to call it the ACLU case, because we could thereafter always say the ACLU defeated censorship on the internet. The problem was, of course, as I said, the ACLU didn't have a website. We weren't at risk of being prosecuted under the internet, under the statute, because we didn't have a website. And so we got a website, and we started putting up things like the address of the ACLU and, you know, how you could give us donations. It's the first thing every nonprofit puts up on the internet. And we had a little trouble figuring out, well, what is it that's on our website that is indecent, that is going to cause us to be at risk of getting prosecuted under this law? And there wasn't anything. So we started scrambling around to try and think of a way to get something on the website that would be indecent. Well, this whole concept of indecency comes from a television case, a case involving free speech on TV, involving actually radio, but the same principle, involving George Carlin, the comedian George Carlin. George Carlin had a very famous monologue, 7 Dirtiest Words in the English Language, in which he repetitively and very humorously discusses the 7 dirtiest words in the English language and how you can't say them on TV. And he says things like, they must be really scary words if there's only 7 you can't say on TV. And he discusses this at great length. Well, somebody heard the monologue on radio, objected to it, filed a complaint with the FCC. The FCC censored the radio station and went up to the United States Supreme Court. Can you censor a TV station or radio station for using essentially the 7 dirtiest words in the English language? And the Supreme Court said yes, somewhat to everyone's surprise, frankly. Well, we began thinking about that case, and the more we thought about that case, the clearer it was to us that that was what the real fight in the CDA case was going to be about. See, the CDA case was going to be about you can use the 7 dirtiest words in the English language in books. You can't use them on TV. The First Amendment says those are both true. And so the fight, we thought, was going to be about which model is going to apply to the internet. Is it going to be the TV model where you can't say those words, or is it going to be the book model where you can say those words? Well, we started out nervous about that question, and in fact, there were people who urged us not to bring the case because we couldn't win it. And we were nervous about it. The rationale for allowing more censorship of TV and radio is it comes into your home unbidden, and it pops up in front of your ears or your eyes before you have a chance to do anything about it. Well, what little we understood about the internet at the time, it came into your home, and it came into your home on a screen that looked sort of like a TV screen. If you were thinking about metaphors, if you were thinking about analogies, the TV analogy was a pretty good analogy. And particularly since nobody really understood the internet, we were very afraid that the internet would end up being censored in the same way that TV is. So that was our principal concern. But the more we thought about that, but in terms of getting the ACLU into the case as a plaintiff, we thought to ourselves, well, look, the only thing in the world we know for 100% certain is indecent is George Carlin's monologue. George Carlin's monologue is attached to as an appendix to the Supreme Court's opinion in the George Carlin monologue case. So we put the opinion in the appendix on our website. Now, we thought that was pretty good, actually. We thought that might very well get us sufficiently into the case. But we were a little nervous because it was, you know, there's no argument in the context of indecency that you can be both indecent and educational. Unlike obscenity, where if it's educational, it's not obscene. You can be both educational or of scientific value and so on and still be indecent. Nevertheless, we thought the Supreme Court might be troubled about declaring that its own opinions can't be put out in public. So we decided to hold a contest. We discovered that there was an interactivity to the internet. Who knew? That was so cool. And so we decided to hold a contest, and we held a contest on asking people who came to our website to guess what are the 7 dirtiest words in the English language. And you typed in what you thought were the 7 dirtiest words in the English language, and then you clicked, and it took you to the George Carlin monologue site so that you could figure out whether you got it right or not. Well, You will not be surprised to learn that it turns out there are more than 7 dirty words in the English language. We did not have any trouble finding additional words that people might very well find indecent. And as a result of those two things, we made the ACLU a plaintiff, and successfully, it never really was seriously litigated. So the ACLU stayed as plaintiff, and the case was called ACLU versus Reno. When we got to the law that was passed required that the case be heard by a special 3-judge court consisting of 1 Court of Appeals judge and 2 district court judges. The chief judge of the Third, we filed it in Philadelphia, largely because the Third Circuit was a very good free speech circuit. The chief judge of the Third Circuit appointed herself to the panel. She thought this was a pretty cool case, too. And you know, sex, the First Amendment, and a new technology, that's pretty cool. So she appointed herself to it, and she appointed another district court judge, and we went to Philadelphia, and we had a full-blown trial. Well, at the trial, at the time we started the trial, not a single one of the judges nor any of their law clerks had ever been on the internet in any way, shape, or form. They did not know what it was. They did not know what it looked like. They did not know what you could accomplish on it. They didn't have any idea what it was about. So we ran a wire into the courtroom, and we brought some computers in, and we brought people in to show them what the internet was. And we had literally had a demonstration, which I know to those of you who are younger seems absurd at this point to demonstrate what the internet is. It's sort of like demonstrating what TV is. But that's what we did. And I can tell you the court was rapt in interest. They thought this was so cool. And they loved it, and they totally loved it. We did that in 4 or 5 cases of our first internet censorship cases. We wired up the courtroom. So we had this almost a month-long trial in the ceremonial courtroom in the United States District Court in Philadelphia. One of my favorite stories is the court brought in its own historian to take our picture at counsel table. I thought that was pretty cool, actually. The fact that the court thought this case was important enough that they were going to do that, I thought that was sort of cool. And we had this whole big trial, and much of the fight at the trial was about what does indecency mean, what is indecent, what isn't indecent, is indecency something we can punish, is it not something we can punish? But the bigger fight was over this, and on that issue, we really tried very hard to put on evidence of the kind of speech that was on the internet, we had to think of speech, and this is a theme that will come up again. You had to think of speech that was sexual enough that it was at risk under the statute, but not so sexual that the court wouldn't want to protect it. So we needed to find the kinds of speech that tiptoed along that very fine line. We used the ACLU's 7 Dirty Words contest. We used a place called Stop Prisoner Rape, in which prisoners who had been raped while in jail or prison shared the experiences of what it was like to be raped in prison. We used something that it involved a sexual health network, which involved giving advice to physically disabled people on how they can achieve sexual gratification given their particular disability. Those were the kinds of things we looked for. Planned Parenthood was a plaintiff in that case. Those are the kinds of things we looked for. And we fought about the model to use. Is there a model should we use the TV model or should we use the book model? We won in the district court. Case goes up to the United States Supreme Court. At the time the case is argued in the United States Supreme Court, none of the justices had ever been on the internet. None of the justices had ever seen the internet. They heard the case. They then, after hearing the argument, they then went, as I'm told, I don't know that, I'm told this is true. A couple of their law clerks who had been on the internet took them down in the basement of the Supreme Court and showed them what the internet was. And then they decided the case. And we won, essentially. We won, and the most significant thing about the case is we won essentially 9-zip. And the Supreme Court declared unequivocally that the model to be used for the internet is books, not TV. This is a gigantic victory, because what it means is we don't ever have to fight about whether it's one of the 7 dirty words or not. We don't ever have to fight about whether it's indecent or not. What we didn't expect, and what was sort of odd about the opinion, is it cast real serious doubt on the concept of indecency as being unconstitutionally vague. Well, the Supreme Court had already decided that that precise word was constitutionally precise when applied to TV. It it was a little hard for anybody to understand, including us, why it was imprecise when you applied it to the internet. Same word, same legal structure, same plan. Congress, in fact, was quite puzzled by it as well, I will tell you, and they were unhappy that the Supreme Court decided the way they did. So the next thing, and there's one other fight that's going on in CDA that I need to prefigure for what comes next, which is one of the things we said is even if there's a compelling interest in protecting children from indecency, this is not the least restrictive, most effective means by which you can protect children. One of the things in First Amendment law is, first of all, if the government wants to censor speech, it has to show that they have a compelling interest. And second, they have to show that the censorship is narrowly tailored to achieve the government's interest. And we mostly conceded that there was a compelling interest. We put on one witness to suggest that there is no compelling interest in protecting children from speech about sex. The court was astonishingly unimpressed with the witness. I thought he was actually very impressive. Happened to be a minister as well as a sexologist. But the court expressed its concern that the testimony was not relevant. So we put on evidence that there is existing in the market software that will censor the internet for you if you want it to. It's blocking software, internet censorship software, filtering software, it goes by various names. You can now get it from almost any, you have to get it now from any ISP. You can buy it privately. It's now in Vista. It's bundled as part of Vista. And it is, once you turn on this software, it will go through and censor speech in the categories that you ask it to censor speech. And you can censor speech about sex if you want to. You can censor speech about hate if you want to. You can censor speech about guns if you want to. You can censor dating sites. You can censor hacking sites. They have various categories, and the companies purport to go and look at the entire internet and categorize websites into these various categories. And if you turn on, please block sex, it'll block the websites of sex. And we said to the court, that's a less restrictive alternative. It doesn't impose censorship on people who don't want the censorship, and it allows people who do want to censor their own computer to censor their own computer. And that's all unequivocally true. So unfortunately, that came back to haunt us in the next case that we did, which involved a federal law that required schools and libraries, public schools and public libraries, if they get federal funds, to turn on blocking software and to have the blocking software turned on to block speech about sex. The Children's Internet Protection Act, which we used to refer to as CHIPA. Everybody else called it CIPA. We thought it was crueler to the law to call it CHIPA. CHIPA required that every library in the country and every school in the country block speech about sex on their internet access computers if the school or library was receiving certain kinds of federal funds. So we just won this very big case talking about how wonderful blocking software is, how it's so much better than a criminal statute. It's the best thing that ever happened to the internet. It allows you to personalize all of this all the way you want it. And immediately Congress says, all right, you want blocking software? We'll give you blocking software. And we say, oops, well, we like it, but not that much. We don't like it when it's mandatory. We only like it when it's voluntary. So we sued over CHIPA. And there were a couple of interesting fights in CHIPA, which this is slightly peripheral. I bring it up only because it covers this issue of blocking software, which is a recurrent theme through all of these cases. We had a big fight about what is a library. We didn't sue over schools, frankly. We thought we couldn't win over schools. We only sued over public libraries. The American Library Association was one of the plaintiffs. We represented a number of libraries and library associations. And there was a big fight about what is a library. What is the role a library plays? Does a library essentially only give you Huck Finn and War and Peace? Or does it also give you Jekyll and Suzanne and Playboy? And surprisingly, the library community is pretty united on the view that it gives you what you want. Now, to be perfectly honest, they're a little hypocritical about that. The truth is you can't get Playboy in most libraries. You can in some, but you can't get it in most libraries. But the library code is we're here to provide the resources that the patrons want, not the resources that the library thinks the patrons should have. So we had that fight during the CHIPA case. We also had a very big fight over the adequacy of blocking software. And in this instance, the government and we switched sides. In CDA, the government was saying, oh no, blocking software is flawed, it doesn't work properly, it's not adequate, we need a criminal statute because if we don't have a criminal statute, it's not going to work adequately and stuff will slip through, kids will see nasty stuff, it's just not good enough. Now, and we were on the other hand saying, well, it's good enough, and certainly better than a criminal statute. So now we're on the side of saying this is terrible stuff, this doesn't work at all. And the government's on the side of saying, oh, no, 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 this is the best thing that ever happened to the world. This is just absolutely fabulous. I mean, this is wonderful stuff. And so both sides put on a considerable amount of evidence on how blocking software works. And the consensus at that point was that blocking software overblocked substantially. Overblocking means when it is trying to block speech about sex, it in fact blocks speech that isn't about sex. My favorite personal example was the Republican National Committee was blocked. The webpage was blocked by one of the companies as a sexually explicit site. I'm not going further in terms of whether how appropriate that was or how appropriate it wasn't. And so we put on a lot of evidence about how flawed the software was. The government put on some evidence about the fact that it was reasonably good. And the truth is that was all somewhat inconclusive, frankly. It's hard to do a study of this kind. And what the case ultimately began to turn on was the turn-off provision. There was a provision in the law that said the librarian had the authority to turn off the software under certain circumstances. And so a lot of the fight began to be over the question of when the librarian could turn off the software and for whom the library could turn off the software. And there was a very big fight amongst the legal team, just within our legal team, about whether we should argue that the librarian has the authority to turn off the software when a kid is using the computer or not. Largely never resolved. We won in the trial court. Again, it was a special three-judge court. Again, we did it in Philadelphia. Again, the chief judge, this time a different chief judge, appointed himself to the court because he thought that was a cool case. The court historian, as far as I know, didn't come. But we won in the district court in a very long and very scholarly and very thoughtful and incredibly persuasive opinion. And went to the Supreme Court, and we lost in the Supreme Court. And we lost in the Supreme Court in a series of opinions which I defy anyone to make sense of. I'm telling you right now, you won't be able to understand them if you read them. They don't make any sense. But part of the problem turned on this turn-off provision. The court decided that under the statute, they thought it was probably permissible for any patron to get the software turned off anytime they wanted, and under those circumstances, they didn't have a problem with the statute. The truth is, I'm not sure I don't have anywhere near as big a problem with the statute if any patron can get it turned off at will either, but that's not the way it works. In fact, once it's on, most libraries won't turn it off for anybody, adult or minor. So while the CHIPA fight is going on, Congress is still fretting about the fact that we won CDA and that there's all this indecent speech on the internet. Congress is very much in a tizzy about that. And what happens in these instances is somebody decides this is a terrible thing, that kids can get access to things on the internet. And so somebody wants to pass a law prohibiting kids from getting access to really filthy stuff on the internet, and they introduce the law. Well, if you're then your average senator or your average congressman, it is very hard to vote against that law. It is very hard to know that at your next election, your opponent is going to say, he voted to give hardcore porn to children. So they all vote for it. And more than one says to the ACLU lobbyists privately, of course it's unconstitutional. Geez, who are you kidding? Of course it's unconstitutional, but we had to vote for it anyway, and the courts will fix it up. I'm a big fan of judicial review. I'm a big fan of the courts being able to strike down statutes as unconstitutional. But this is one of the downsides of judicial review, which is it allows legislators and presidents and governors and mayors to hide behind to do politically popular things even when they know it's unconstitutional on the theory that the courts will take the heat and the courts will fix it in the future. And that's what happened with COPA. So now we've got the Child Online Protection Act. You get a theme before these various titles? There's a certain theme going on. Child Online Protection Act comes along and Congress passes it, the president signs it. It prohibits not speech on the internet that is indecent, it prohibits speech on the internet that is harmful to minors. Harmful to minors is defined in COPA as speech that essentially uses the obscenity standard, only it adds the word for minors to the obscenity standard. So that, for example, it says it must be prurient, which is part of the obscenity standard, for minors. How it is that things are prurient for adults but not for minors or vice versa, I don't know. It must lack social value for minors. And it must, what's the third one? I've forgotten the third one. But the third one is also for minors. Patently offensive. Patently offensive according to contemporary community standards for minors. I have no idea what this means. And our thought, they also slightly narrow the scope of the internet that is covered. COPA only covers the web. CDA covered the web and email and news groups and listservs and everything else. COPA only covers the web. We went into COPA thinking, oh good, they did it again. They're just as stupid this time as they were the last time. We're going to go in. We won CDA 9-zip. We're going to go in year, and this will be over. We'll wipe this out in a second. This isn't even worth doing, because the rationales behind the fact that the internet was entitled to the same sort of protection as books still applied, and we thought this was going to be really easy. Well, it wasn't. It took us 10 years to effectively kill that statute. Fortunately, during the entire fight, the statute was enjoined. The statute never went into effect, but it took us 10 years to put the final nail in the coffin of the statute. Went to the Supreme Court 3 times with 2 decisions from the Supreme Court. It was tried 3 times in the district court, 2 of which were roughly a month-long trials. It took us forever to finally kill this. But you'll notice now since we're back in CDA world, we're back in the world of a criminal statute that prohibits speech on the internet. The government and we have flipped once more. We're back to saying internet filtering software is just the best thing there ever is. Internet filtering software is voluntary, it's less restrictive, it's just wonderful. And the government's back to saying this is the worst stuff that ever existed. It's terrible. It doesn't protect children at all. I happen to think their hypocrisy is more serious than our hypocrisy. And I can explain to you why we're not being hypocrites. But both of us have this disconnect. And both of us tried to use evidence that the other had presented in one of the prior cases in order to make our point. It was a bizarre experience in that way. So we approached this case basically in the same way we approached CDA. There was a trial. One of the issues in the trial was the competency of blocking software. The government spent $1 million on a study to determine the effectiveness of blocking software. They subpoenaed and obtained from Google a random sample of websites, a random sample of searches done on websites. And they ran then that random sample through about a dozen of the most prominent blocking software programs to determine, and then to see which ones were blocked and which ones weren't blocked, and then they made their own judgment as to whether the blocking software got it right or got it wrong. The results actually surprised everybody, and surprised me, surprised everybody. And the results fed directly into this contradiction I keep talking about. The blocking software is over 95% effective in preventing access to sexually explicit material. Some of it was 98 points, the best was 98.7, AOL's was 98.7% effective in blocking access to material that was sexually explicit on the web. That's a pretty dazzling statistic. So let's talk about that statistic for just a second, and then I'll tell you the other part about blocking software. The COPA statute applied only to the web. It wasn't going to protect children from from porn that was on news groups. It wasn't going to protect children from porn that was in email. It wasn't going to protect children from porn that was videocast, because videocasting doesn't use the same protocols that the web does. It wasn't going to protect kids from audio casting. And most interestingly, and what ended up being most persuasive to the court, it wasn't going to protect kids from anything overseas. This was a domestic U.S. statute. The only people that the United States government was going to be able to prosecute under this statute was people who were in the United States. We put on a fairly impressive study that said that roughly 50% of all sexually explicit speech comes from overseas. So by definition, even under the best of all circumstances, COPA was only going to suppress 50% of all speech about sex on the internet in order to protect children. And what that means, stop and think for just a second about the way the internet works, therefore, and what that means. What it means is if a kid goes onto the internet, let's assume COPA goes into effect. Kid goes on the internet, kid puts the word sex into Google and hits the search, hits the button. It's not that nothing comes up. 100 million sites are going to come up. They're all going to be .ru or .fr, or they're all going to be overseas sites. But as I said at the very beginning, they're just as accessible as the domestic sites. It doesn't really stop kids for a half a second from getting access to sexually explicit material. And it's interestingly, in part because the internet is an international medium. And it's becoming, in the same way it's very hard for states to regulate the internet, it's becoming harder and harder for nations to regulate the internet because of its international qualities. So you've got the COPA, which is right off the get-go 50% ineffective. And then it's also ineffective because it doesn't cover video, and it doesn't cover newsgroups, and it doesn't cover all the other, any non-web form of internet communication. And you've got software that's 98.7% effective. It's pretty hard to defend the statute at that point. The government says, well, but we need belts and suspenders. We need to have, it's only 98% effective. And the government's, their strongest argument was roughly 50% of the parents don't actually turn it on, don't use the software, have decided not to use it. And therefore, their argument is there's still 50% of the kids that aren't going to be protected. And we said, well, that's because their parents chose not to turn the software on. You can't say they're not being protected. You can just say that the parents have different values than the government has. The other thing we said when they made the belt and suspenders argument is if you have a really, really good belt, you don't throw someone in jail for not wearing their suspenders. And we have a really, really good belt, a 98.7% effective belt. So that was one of the big fights in COPA. And oddly enough, it was the government's testimony that was most effective for our side, I think. The other fight, you'll recall now that I said that in CDA, one of the big fights was over whether the word indecency was vague or not. Well, we decided to take on the issue of whether the standard for harmful to minors was vague or not. Nobody thought we could win that. We didn't actually win it. We didn't lose it, but we didn't actually win it. But I think it colored the nature of the case a lot. So as I said, think about what prurient means, sexually arousing. And think about what speech is it. Remember, obscenity is illegal on the internet. Obscenity is illegal regardless of all these cases. Obscenity is illegal on the internet. It's illegal in books. It's illegal in magazines. It's illegal in movies. It's illegal everywhere. So we're talking about something less than obscenity. Taking each of the various parts of the statute, what is it that's prurient for adults, i.e. obscene, and not prurient, or the other way around, I said it backwards. What is it that's prurient for minors, i.e. harmful to minors, but not also prurient for adults, i.e. obscene? It's a little hard to come up with an example. The other two standards, patently offensive for minors and lacks social value for minors, are a little trickier. But then you have to start asking yourself the question, what does it mean to talk about a minor? What is a minor? So the statute says a minor is anyone under the age of 17. So we kept saying to the government, okay, tell us what it is that lacks value for a 16-year-old but has value for a 17-year-old. What is it that's patently offensive for a 16-year-old and not patently offensive for a 17-year-old? And law always draws all kinds of lines, and sometimes the lines are arbitrary, and we all understand that, but we're talking about the First Amendment. We're talking about free speech. And you're talking about drawing a line that we can't make sense. The government bitterly, bitterly resisted the idea of answering those questions. The judge finally forced them to answer those questions, and they said they couldn't come up with a single example. I happen to think that was pretty devastating. I happen to think that suggests that the statute is wildly vague, and the judge did find the statute vague, but for other reasons. My favorite example of this is we said to the government, okay, we're going to push you a little farther. I wanted to do a deposition of the chief prosecutor, and I wanted to be able to show him images and say, is this obscene or is this harmful to minors, and tell me why you've distinguished this one from that one. The judge wouldn't let me do that. But I did get the judge to require them to respond to roughly 12 exhibits that we gave. And there were 3 that stand out in my mind. One was a Playboy image, essentially a series of women on the web page, all of whom were naked, naked from the waist up. And basically just sort of standing, posed. There was no sexual activity taking place. It was individual women posed. There was a picture from Penthouse Magazine's website, almost identical, also women naked, also women basically just standing there looking at the camera. And there was a picture from a third website that I've forgotten the name of the title, but it was also a picture of women standing around naked from the waist up. Only this particular website had imposed stars over the nipples, the women's nipples. And we said, which of these is obscene and which of them is harmful to minors? And the government's answer was, none of them are obscene. Apparently, women's breasts are not obscene in the United States anymore. Interestingly, as a side note, the government has brought 16, we asked how many obscenity cases, if this is really so important, if you're so concerned about kids being protected from speech about sex, how many obscenity cases have you brought in the internet context in the last 15 years? And the answer is 15. There have only been 15 federal prosecutions for obscenity in years and years and years. Obscenity is essentially not prosecuted anymore. I mean, it's just a joke. The notion that these laws are passed for symbolism, not for reality. But anyway, so we said, which of these, so they said none of these 3 pictures are obscene. Which are harmful to minors? Well, they said the Penthouse one is harmful to minors. You know that Penthouse. It's a little bit of a raunchy magazine, and therefore, even though the pictures look almost identical to Playboy, that one's harmful to minors. Playboy, no. Playboy's not harmful to minors. Playboy's just fine. That's a little bit of more of a clean cut, important people get interviewed in Playboy. Now remember, we're not looking at the interviews, we're looking at a single web page. We're looking at a single web page, and the statute judges on the basis of a single web page, and yet, so they said Penthouse isn't harmful to minors. Well, the most astonishing thing is the woman with the stars superimposed over the breast, that was harmful to minors. So the Playboy where they were fully unclothed, was not harmful to minors. The stars were. And I'll be darned if I can explain to you what the rationale of that judgment was. I never was able to get an answer to that judgment that made any sense to me whatsoever. But that was the official position of the United States government prosecutors. I thought that was remarkable. The other interesting thing I should talk about briefly with respect to COPA, the other sort of interesting thing is something I alluded to earlier, which is the issue of what kind of testimony to put on. So once again, we're in this very difficult posture of trying to figure out what speech can we tell the judge is at risk under the statute that the judge is going to want to protect. The truth is that we didn't represent Playboy. We could have, we didn't. The judge isn't going to care about protecting Playboy pictures. He just isn't. The Supreme Court's not going to care about protecting those pictures in the same way that they would if we could get something substantially more valuable. So we began sort of trying again to dance this fine line between what is so sexually explicit that it is reasonable to believe it'll be prosecuted under the law, and remember the law has a social value exception, so if it has social value for minors, it's not a crime. So we got to get something that at least colorably could still be prosecuted. And yet we want something that's so valuable that the court feels like it's worth protecting. We went, I will say, a little farther down the prosecutable line than we did in CDA. We put on, my favorite witness of ours was a rapper named Goddess. Goddess is a very young woman, lesbian rapper. Her most famous and perhaps controversial song, which I'm sure you all would hum along with me if I started doing it, is called Lick It. This lesbian rapper has a song called Lick It. Get the point? And she has been censored for this song. We put her on. My favorite part about Goddess's testimony, we played the song in the courtroom, the judge said, okay. But my favorite part about this is, you now have an image of this woman in your head, right? So the first question is, how did you get involved in music? My parents are both classical musicians. I started the cello when I was 2. I loved Goddess. She was just fabulous. But to me, that was a perfect example of, this is not a pornographer. If what you're worried about, Judge, is that you're going to strike down this law and you're going to be protecting pornographers, this woman is not a pornographer. This woman is an artist, a musician, a serious musician. And even if you don't like her music, even if you don't understand her music, she's a serious musician. We put on a film artist from the Art Institute in Chicago who does very sexually explicit artworks on film. She's an artist. It's not porn. And she has a whole very careful explanation as to why it's art and what artistic benefit gets out of it. I thought she was a fantastic witness. And we did, now we had more, as the announcement that you may or may not have seen for this talks about, we had more mainstream clients as well. We put on the editor of Salon magazine. Salon has had articles about sex that have been pretty frank. We had the Urban Dictionary. The Urban Dictionary is a Wikipedia-like site for diction. It's a Wikipedia-like dictionary, not encyclopedia, and it allows people all over the world to define words, including the 7 dirtiest words in the English language and all the words that could have been the 7 dirtiest words in the English language. So we had a lot of fairly mainstream clients, but we also went as far as we could down the line of these people are at risk. We wanted to be, what we didn't want to do was lose on the grounds that our clients were not at risk. And here's why we were troubled about that. During the CDA dispute, Justice Breyer, it was the first COPA argument. As I say, COPA went to the Supreme Court 3 times. The first COPA argument, Justice Breyer basically said from the bench, I don't understand what this case is all about. None of your clients are in this tiniest bit of risk under this statute. And we said, well, wait a minute. Let's look at the language of the statute. Let's look at the speech we have. And we said, the government has conceded that we'll prosecute some of our clients under the statute. And he said, nah, if they do that, I'll strike it down. Well, first of all, Justice Breyer, you're only 1 of 9. You arrogant. Yeah, exactly. But when we went back to the trial after that argument, we were thinking to ourselves, how are we going to deal with Justice Breyer's concerns? How are we going to convince Justice Breyer that our clients really are at risk and that notwithstanding his willingness to start looking at things down in the basement of the Supreme Court, our clients are still at risk? And that's why we began edging farther and farther toward more sexually frank stuff. So we win at every stage of COPA, and just a month or 2 ago, the Supreme Court denied cert. So the COPA statute is dead. Let me spend 2 minutes talking about where I think things are going next. The CHIPA fight is not over by any means. The CHIPA fight is the schools and libraries fight. Free speech in schools is under attack in every conceivable way you can imagine, including speech about sex, and we are losing everywhere in sight. Most recently, the Bong Hits for Jesus case, which we lost badly, and in which the Supreme Court is coming close to saying that students have no free speech rights, notwithstanding the Vietnam War era case of Tinker. There is entirely possible that there'll be a new federal law trying to censor speech about sex on the internet. It is one of the things, speech about sex often drives new technologies. The biggest sales in video cassettes, when video cassettes first came out, was porn. Some of the biggest, most successful websites were porn sites when it first came out. It is a medium that it is a form of communication that generates interest in new media. It's also a form of communication that generates new interest in Congress, and so Congress may well come back and try and do it again, although, frankly, I don't know what Congress can do. And then the last thing I want to talk about is there's a new case in the Supreme Court right now going all the way back to the to CDA on the indecency standard. Fox TV is challenging the constitutionality of the indecency standard, largely as a result of Janet Jackson. Janet Jackson, as you all know, had a wardrobe malfunction at halftime at the Super Bowl. It exposed one of her breasts. The television station was fined, and the dispute about whether the rules for TV that say TV is more censorable than books. There's a fight going on in the United States Supreme Court right now on precisely that question, and we will know something more, I don't know what, by June. So that at least is where we are on the story of censoring speech on the internet so far, and I'd be happy to talk about any of those subjects with anybody who wants to. Thank you. Who has questions?
Well, I apologize. I missed the first couple of minutes. If memory serves me correctly, ACLU versus Reno was 96, 97. Is that correct?
I don't know. It sounds about right.
Okay. But yet you did not have a website at that time?
That's right. We did not.
And I'm not one of those younger people.
No, in fact, nobody I knew had a website. Nobody we knew had a website at the time. I still vividly remember going down to Washington to let someone show me what an internet website looked like. Yeah, well, no, there clearly were websites. We didn't have one. The ACLU didn't have one. Yeah.
I teach at the high school level, and I'm interested in just maybe hearing your summation of where you think student speech is then after the bomb hits for Jesus case, and where have we, basically where are we left between that and the Tinkers and now this, and where do you think the status of free speech for students is currently?
I don't think students have any free speech rights at the moment. Whether we can roll that back or not, I don't know. But if you're a student, your free speech rights are in grave peril. I think we still win armband cases. You get close enough to tinker and we can still win it. And the more political it is and the less it is other things, we can still win some of those. And a lot of schools are still willing to engage in free speech. And you get things like the religious clubs statute, which helps because it used to be banning Christian clubs from high schools, and Congress passed a law that said if you have one club, you have to have all the clubs. That was designed entirely and exclusively for the purpose of ensuring that Christian clubs could be in high schools. We've used it very successfully for gay-straight alliance clubs and the free speech issues that surround clubs like that. So there are some bright spots, but the United States Supreme Court at the moment does not seem to think that students have any free speech rights worth protecting. Yeah.
There's a new category of cases I see popping up with this whole sexting issue, where you have especially teenagers who send naked pictures of themselves to their boyfriends or whatever, and they're getting prosecuted for being sexual offenders. Given that teenagers have no rights, but also given that these are
students have no rights.
Okay, given that students have no rights.
One of the huge fights in student speech issues is off-campus versus on-campus speech.
Okay. So yeah, I guess I'm also wondering where the using the cell phones, if that's going to be treated the same way as the internet. Where do you see that going?
Well, the thing about the sexting cases is that we're talking now. So far, almost everything I talked about was obscenity, indecency, and harmful to minors. Now we're talking about child porn. And the thing about child porn is there are no exceptions for child porn. It doesn't matter if it's socially valuable, doesn't matter if you had it for educational purposes, it doesn't matter, nothing matters. If you possess child porn, it's a crime, you go to jail. And the sexting, the pictures that people are being arrested for in the sexting context fit the definition of child porn. It's the concept of prosecuting a 15-year-old girl for taking a picture of herself seems absurd to me, but I welcome anybody in the room who has an idea about what legal challenge we can make to those to the application of that statute to those contexts. I haven't yet come up with what I think is a persuasive legal challenge. I mean, there are policy challenges and there are fact challenges, but I'm not yet sure I've figured out a legal challenge. Yeah.
Yes, sir. Speaking of the Supreme Court and looking toward the future, if you had your choice, can you tell me one or two people who you'd like to see retire before some of these issues?
I don't think you would have any difficulty guessing what answers I would give to that question.
Well, there are differences. I could name some names.
Actually, maybe I will surprise. Robertson and Alito, I think, would be my top two. And the reason I picked them rather than Scalia and Thomas is because they're younger.
Yeah.
Oh, yeah, sorry.
In Michigan, Edsel Ford High School in Dearborn, Michigan, the teacher or the principal and the Board of Education discontinued the school newspaper and also the website because one of the students wrote an article which they deemed political and not acceptable to the school. What is the recourse of those students, if any?
Depends on what the nature of the newspaper was. If the newspaper was a curricular or school-sponsored newspaper, there's no recourse. If it was a non-school sponsored newspaper, you should call the affiliate and we'd be happy to get involved. But curricular newspapers, there's nothing you can do. School gets to decide. I don't agree with the decision, but that's what the Supreme Court says. In the back up there.
Yes, I'm an educational technologist, and I'm finding more and more it's nearly impossible to design technologically enhanced learning environments and implement them in schools because of these legal issues. And I was wondering if you could speak at all about the relationship, for example, between the '96 Telecommunications Act, E-rate funding, and COPA, for example, or others of these laws that you've been speaking about.
Yeah, the only federal law that has anything to do with what can be done and can't be done in schools is CHIPA. And the Supreme Court says so long as a school is taking E-rate money, they have to comply with CHIPA. CHIPA requires that there be installed and operating blocking software that prevents access to speech that is harmful to minors. CHIPA also provides that faculty and staff have the authority under certain as yet undefined circumstances to turn the blocking software off. Whether that means turn it off for a person or whether it means turn it off site-specific is not yet clear.
So now we have children that play this software as if it was a video game. And they win every single time. And so the response has been, or when they want to, the response has been, and it's not usually about porn, the response has been to implement hardware filtering as opposed to software filtering that is much more aggressive. I don't know if you can speak to that or speak really to the whole field of the implications for children and their rights and their free speech and their inability to learn in schools the way they learn outside of schools.
Yeah, I mean, this is an issue that's essentially irrelevant to the internet. I mean, the issue you're raising is should we teach students in our schools along a narrow path, or should we open up their minds to all sorts of options? And that's, I think, an educational philosophy question, not a legal question. And, you know, for the most part, the Supreme Court says that schools get to make the decision as to which of those paths they want to choose.
The hands are held pretty much.
Well, no, the only requirement, the hands are not held, because the only requirement that I know of from federal law is sex. The only thing you have to censor in schools is sex. Now, everything else is your own decision. Your hands may be tied for political reasons. That's a whole different ballgame. But for legal reasons, the only thing I know of that you're tied up on is sex.
I just wondered if you knew of any cases where there's censorship on the internet as a result of hackers which appoint themselves internet policemen to prevent certain pages from being printed out. Okay, recently I know of somebody who got this article on Islamic law, and it said in the article on Islamic law that that some of the roots of American jurisprudence were in Islamic law dating back from the caliphs of many centuries ago. And it's like only that page, which had this information, came out blank. I was wondering if you knew anything about it.
Well, no. The short answer is no. I don't know anything about it. Slightly longer answer: the Constitution only protects against censorship by the government, not censorship by private individuals. So private censorship can't be challenged under the Constitution. So if I'm the one that somehow got to your ISP and got that page censored, you can sue me for lots of, there may be things you can sue me for, but you can't sue me for violating the Constitution.
I have a question about the on-campus, off-campus situation with MySpace and Facebook and the fake profiles. I mean, how far do those go unprotected, or how protected is your Facebook page?
Should or are. It is the ACLU's view that off-campus speech, even if it has on-campus implications, should not be punishable by the schools. May be punishable in other ways, depending upon what it is. But the principle, if you post something on your MySpace page, even if everybody at school is talking about what you posted on your MySpace page, it's our view that the principal has no right to intervene whatsoever. We're winning some of those cases. We're losing some of those cases. It's not that's still a very unsettled area of law.
And now, also, what about Twitter? Now, I mean, does that kind of cross into the line of on campus? Because if it goes to your cell phone from a website.
Yeah, the added question of what you can do with cell phones, the courts have not even begun to start thinking about that intelligently. I mean, their whole range, the cell phone is rapidly becoming the internet itself, and it's rapidly having as much access as a laptop or a desktop. And nobody's really thought carefully about that. What a lot of schools are doing is banning cell phones. That produces all sorts of other problems. So there are lots of parents who are in fact very upset at the idea that cell phones are being banned in the schools because the parents want to be able to reach their kids, or more interestingly, have their kids be able to reach them. All of that could not be more unsettled, and there's no answer to any of those questions. There isn't even a hint of an answer to any of those questions.
All right, on that, we'll end.
You want me to end on I don't know?
And please join us for a reception with Chris out in the main lobby after this meeting. Thank you.